Show us your papers. Federal court is restricted.
I'm Judge Blythe Arrington. My credentials are in my briefcase.
Proof? Sure you are. Everyone claims to be someone important. Proof of citizenship now, or you're coming with us for verification.
My name is Judge Blythe Arrington. Call the
We'll verify your story downtown, ma'am.
I've presided over this courthouse for 7 years. Call the clerk's office. Call chambers.
Call anyone inside that. Verify your story downtown, ma'am. Call anyone inside that building. We'll verify your story downtown, ma'am.
The steps of the Harold T. Edwards Federal Courthouse were crowded when it happened. Monday morning, 8:43 a.m. The kind of crisp November air that made the marble shine and turned breath into vapor clouds. Judge Blythe Arrington had arrived for oral arguments in a high-profile securities fraud case. Dressed in her charcoal suit, leather briefcase in hand. The same walk she'd made 1,000 times before. She was 10 feet from the security checkpoint, 10 feet from the metal detectors she passed through every working day, when 3 ICE agents stepped into her path from beside the building's east colonnade. Their body cameras were rolling, recording what would become the most expensive security check in the history of the Department of Justice. Before we continue, where are you watching from? If this is your first time here, you need to hit that subscribe button. Stories like this don't get told unless we tell them. And your support means these videos reach people who need to see what's really happening in our justice system. Agent Keeler Boone led the interception. His partners, Agents Solon and Greer, flanking wide in a tactical spread that screamed law enforcement training. Arrington saw them coming, read the aggressive spacing, the hands hovering near their duty belts, the body language of men who'd already decided she was a problem before checking a single fact. Her judicial brain cataloged it all in the second it took them to close the distance. Federal agents, immigration and customs enforcement patches, visible on their tactical vests, looking at her like she didn't belong on these steps. And like she was an intruder at the very building where her nameplate hung outside a chamber's door on the 3rd floor. She knew where this was going before Boone opened his mouth. She'd read the reports, studied the patterns, ruled on the cases. She knew exactly what racial profiling looked like when it wore a badge. She just never imagined it would happen to her. Here, at the gates of the very court where she'd spent 7 years defending the Constitution, these men were about to violate. Ma'am, Immigration and Customs Enforcement. We're conducting a security sweep of this federal facility. Arrington stopped, briefcase in hand, and looked Boone directly in the eyes. Behind her, attorneys in suits and court staff with ID badges were streaming past the agents without a second glance, entering the building freely. And the message was clear. The sweep had a very specific target. Agent, I'm Judge Blythe Arrington. I preside over courtroom 3B in this building. I'm here for oral arguments scheduled at 9 o'clock. Boone's expression didn't change. If anything, his stance became more aggressive. We're going to need to see documentation proving your legal status in this country. The words hung in the November air like an accusation. Around them, the morning crowd began to slow, to watch, to recognize that something unusual was unfolding on the courthouse steps. A woman in business attire being stopped. 3 federal agents blocking her path. The tableau of power gone wrong. Arrington felt the heat rising in her chest. Not panic, but the controlled fury of someone who'd spent a lifetime mastering her emotions in service of the law. She was about to give these agents a lesson in constitutional limits they'd never forget. Agent Boone, she said, her voice carrying the weight of judicial authority, you are currently violating my 4th Amendment rights. You have no reasonable suspicion of any crime, no articulable facts supporting this stop, and you are preventing a federal officer, yes, a federal judge is a federal officer, from entering her workplace. Boone didn't blink. Ma'am, produce your documents, or you'll be detained for a verification. This is a restricted federal facility. Arrington almost laughed at the audacity. Agent, I have presided over 53 deportation appeals in this courthouse. I know federal immigration law better than you do, and what you're doing right now, this is going to cost the Department of Justice more money than you'll make in your entire career. Behind her, someone pulled out a phone. The recording had begun. Judge Blythe Arrington had walked up these courthouse steps 1,847 times. She knew because her clerk, Sarah, had joked about it at her 7-year anniversary reception last month, calculating roughly 264 working days a year, minus federal holidays, and the occasional bout of flu. The marble was worn smooth in the center from a century of lawyers, judges, defendants, and witnesses, making the same climb toward whatever version of justice awaited them inside. This morning should have been unremarkable. The Hollister Securities fraud case, oral arguments at 9, a probable ruling by end of week. She'd reviewed the briefs over Sunday dinner. She's made her notes in the margins with the fountain pen her father had given her when she passed the bar. Standard procedure for a Monday that was supposed to be like any other Monday. She'd parked in the judicial lot at 8:38, gathered her briefcase and coat, nodded to Judge Pemberton, who was getting out of his Volvo 2 spaces over. They'd exchanged the usual pleasantries about the weather, unseasonably cold for November, and he'd headed toward the side entrance reserved for judiciary, while Arrington had opted for the front steps. She liked entering through the main doors occasionally, liked the reminder of what the building represented to the people who came here seeking fairness. The plaza in front of the courthouse was already busy with the morning crowd. Attorneys in expensive suits, pulling roller bags full of exhibits. To court reporters clutching their stenography machines. A few early defendants looking nervous and out of place in their ill-fitting dress clothes. A normal Monday at the Harold T. Edwards Federal Courthouse. That's when she saw them. 3 men in tactical gear positioned near the East Colonnade, not courthouse security, not U.S. Marshals, who usually handled building protection. ICE vests, clearly visible. Immigration and Customs Enforcement, watching the crowd with the kind of predatory attention that made Arrington's judicial instincts flare. She'd read the reports, seen the statistics in the cases that crossed her bench. Courthouse arrests had quintupled in the past 18 months. ICE had taken to stationing agents near federal buildings, intercepting people they deemed suspicious before they could enter to testify, to file motions, to seek the protection of the law. It was a tactic designed to intimidate, to make courthouses feel less like sanctuaries of justice and more like traps. But this was different. The agents weren't watching the crowd generally. They were watching her specifically. Arrington kept walking, briefcase in her right hand, credentials in her purse, which was slung over her left shoulder. 10 more steps to the security checkpoint. 8. 6. Agent Keeler Boone stepped directly into her path. He was maybe 40, white, with the kind of military straight posture that suggested prior service, and the kind of blank expression that suggested he'd learned to stop seeing people as individuals. His 2 partners moved in flanking formation, creating a wall of federal authority blocking her way. "Ma'am, stop right there." Boone's hand came up, palm out. Seemed not touching her, but the gesture itself was a command. "ICE, we need to see your identification." Arrington stopped, more from shock than compliance. She was 10 feet from her workplace, 10 feet from the building where her nameplate read, Honorable Blythe Arrington, United States District Judge. She could see the security guards inside the glass doors, could see attorneys she knew by name streaming past the agents without being stopped. "Excuse me?" Her voice came out steady despite the adrenaline suddenly flooding her system. "Identification, ma'am. We're conducting a security operation." Boone's tone suggested this was routine, that stopping a professionally dressed woman on the courthouse steps was just another day at the office. Behind him, attorneys, almost all of them white, were entering the building without a glance from the agents. The message was unmistakable. The security operation had one target: her. Arrington felt the moment crystallize into something she'd need to remember precisely, because she already knew where this was heading. She was watching the beginning of what would either be a quiet humiliation she'd have to swallow, or a constitutional violation she'd have to fight. Her father's words echoed in her mind, the same words he'd given her the day she took the bench. Sometimes the law needs a witness. Sometimes it needs a warrior. She looked at Agent Boone's blank face and made her choice. "I'm Judge Blythe Arrington." She kept her voice calm, professional, the same tone she used when explaining complex legal precedents to juries. "I'm the lead federal judge for this district. I preside in this courthouse. I'm here for oral arguments scheduled at 9 o'clock. Boone's expression didn't change. If anything, a slight smirk tugged at the corner of his mouth, the look of a man who'd heard every story, every excuse, every desperate claim to importance from people trying to avoid detention. "Sure you are, ma'am, and I'm the Chief Justice." His partners actually chuckled. "We hear a lot of stories out here. Everyone's always somebody important when we stop them." "I'm not telling you a story, Agent. I'm stating a fact. My chambers are on the 3rd floor. My nameplate is on the door. Call inside. Call the clerk's office. Call literally anyone in that building. We'll verify your claims downtown, ma'am. Right now, we need documentation proving your legal status in this country. Passport, birth certificate, naturalization papers." The crowd was growing now, lawyers slowing their climb up the steps, recognizing that something unusual was happening. A few were pulling out phones. Good, Arrington thought. Let them record this. Let there be evidence. My credentials are in my briefcase. She started to shift her grip on the handle. Don't move. Agent Solon, positioned to her left, barked the command with his hand dropping to his belt. Not to his weapon, she noted, but to his handcuffs. Keep your hands where we can see them. Arrington froze. This was the trap, the impossible position they were deliberately creating. They demanded identification. She said it was in her briefcase. They forbade her from reaching for it. They were manufacturing the very non-compliance they'd use to justify whatever came next. Agent, you just asked me for documentation. When I indicated I could provide it, your partner ordered me not to move. Do you see the logical impossibility you're creating? Ma'am, we don't know what's in that briefcase. For officer safety, you need to keep your hands visible until we can secure the scene. Secure the scene. Arrington repeated the words slowly. Agent Boone, we are standing on the steps of a federal courthouse. There are security guards 15 feet away. There are federal law enforcement officers inside that building. What exactly are you securing the scene from? Ma'am, are you refusing to comply with the lawful order? I'm asking you to articulate the reasonable suspicion justifying this stop. What specific, articulable facts led you to stop me, specifically? She's out of the dozens of people who've entered this building in the past 5 minutes? Boone's jaw tightened. He wasn't used to being questioned, wasn't used to someone who knew the legal standards he was supposed to be following. Most people he stopped didn't know their rights, didn't know the difference between a lawful detention and an illegal fishing expedition. We're conducting an operation based on intelligence. What intelligence? That's not information we're required to share with you, ma'am. Actually, under Terry v. Ohio, you are required to have reasonable suspicion of criminal activity to justify a stop. That suspicion must be based on specific and articulable facts, not hunches or profiles. So I'll ask you again, Agent Boone, what specific facts justified stopping me? The crowd had grown to maybe 20 people now. See a rough semicircle of witnesses watching the confrontation unfold. Arrington saw attorneys she recognized, Michelle Cortez from the Public Defender's Office, James Hartley, who practiced immigration law, Sarah Bennington from the U.S. Attorney's Office. They were all watching with expressions ranging from confusion to dawning outrage. As we continue this incredible story, let me know in the comment where you are watching from tonight. And if you haven't already subscribed, please hit the subscribe button because, trust me, you won't want to miss how this unfolds. Boone looked at his partners, some silent communication passing between them. Then he turned back to Arrington, and his voice dropped to a tone of bureaucratic finality. Ma'am, last chance. Produce identification or you're being detained for verification of legal status. So those are your options. Arrington met his eyes. Agent, I'm a federal judge. I'm standing in front of my courthouse. You have no reasonable suspicion, no probable cause, and no legal authority to detain me. What you're doing right now is a Fourth Amendment violation. And I'm telling you this as both a citizen asserting my rights and as a federal officer warning you about the consequences of your actions. Boone reached for his handcuffs. Turn around and place your hands behind your back. Wait! Agent Solon stepped forward, his hand raised toward Boone in a gesture that might have been caution or might have been theater. Ma'am, we're not trying to give you a hard time. We're conducting a legitimate immigration enforcement operation. We have intelligence that individuals without proper documentation have been using this courthouse as a gathering point. Arrington turned her attention to Solon. He was younger than Boone, maybe 35, with the kind of earnest expression that suggested he actually believed he was being reasonable. That made him more dangerous in some ways. At least Boone's hostility was honest. Agent Solon, I'm going to explain this once, in terms that should be clear to anyone with basic law enforcement training. You claim you're conducting an operation based on intelligence. Let's examine that claim. She shifted her briefcase to her other hand, a deliberate movement that made all three agents tense. Good. Let them be reminded that they were afraid of a woman holding a leather bag containing nothing but legal briefs and a laptop. First, you claim this courthouse is a gathering point for undocumented individuals. This is a federal courthouse. Every person who enters goes through metal detectors monitored by trained security personnel. There are U.S. Marshals inside. There are federal judges, federal prosecutors, federal public defenders. Are you suggesting that undocumented individuals are somehow infiltrating a secured federal facility? We didn't say infiltrating. Second, you stopped me specifically. Not the white male attorney who walked past you 30 seconds ago carrying a briefcase identical to mine. Not the white female court reporter who entered just before I arrived. Me. So let's talk about the intelligence that led to that decision. What about my appearance triggered your suspicion? Solon's jaw worked, but no words came out. Agent Greer, seat who'd been silent until now, tried to help. Ma'am, we're conducting random checks. There's nothing random about this, Agent. Random would mean you're stopping people without regard to race, gender, or appearance. You're stopping me, a black woman in professional attire carrying a briefcase to a courthouse where I work. That's not random, that's profiling. We have operational parameters. Describe them. Arrington's voice sharpened. Describe these operational parameters that resulted in you stopping me. Height? I'm 5'7". Weight? Professional attire? The briefcase that signals I'm an attorney or judge? Or was it simply the color of my skin? The crowd had swelled to maybe 40 people now. Court was supposed to start in 15 minutes. And the lawyers who needed to be inside were instead watching a federal judge dismantle ICE agents' justification for a stop in real time. Several phones were recording. Someone had called to the security guards inside, and Arrington could see them watching through the glass doors with expressions of uncertainty. Boone stepped forward again, his patience clearly exhausted. Ma'am, we don't have to explain our operational details to you. We're conducting law enforcement activities, and you're interfering. Last warning. Produce identification or be detained. I'm not interfering, Agent Boone. I'm exercising my constitutional rights. And I'm doing something else, too. I'm creating a record. Because when this stop is challenged in federal court, when your actions are examined by a jury, they're going to want to know what specific, articulable facts justified detaining a federal judge on the steps of her own courthouse. If you're still with us, don't forget to subscribe and share where you're watching from. There's so much more ahead. She gestured to the growing crowd. There are now approximately 40 witnesses watching this encounter. Multiple people are recording on their phones. The courthouse security cameras, she pointed to the 3 cameras covering the plaza, are capturing every moment. So let me ask you one final time, for the record that's being created right now, what specific facts gave you reasonable suspicion to stop me? Solon and Greer looked at Boone. It was his call, his operation, his decision. And Arrington watched him make the calculation she'd seen countless times in her courtroom. The moment when someone realizes they're wrong, but they're too committed to back down. So they double down instead. We observed a potential subject matching parameters for an ongoing investigation, Boone said finally, his words careful and rehearsed. We approached to verify identity and legal status as part of our enforcement mandate. What parameters? That's operational information. What investigation? Classified. Arrington nodded slowly. So to summarize, you have no specific facts, no articulable suspicion, and no legal justification. You have parameters you won't describe, and an investigation you won't specify. Agent Boone, what you have is a hunch based on seeing a black woman approach a courthouse. Sorry, and that's not law enforcement. That's racial profiling, and it's unconstitutional. Boone's hand went to his handcuffs again. Turn around. Now. Arrington didn't turn around. Instead, she raised her voice, projecting the way she did when addressing a crowded courtroom, making sure every witness could hear. For the record, I am Judge Blythe Arrington, lead federal judge for the United States District Court for this district. I am standing on the plaza of the Harold T. Edwards Federal Courthouse, where I have presided for 7 years. It is now 8:47 a.m. on Monday, November 18th. I am being detained by 3 ICE agents, Agent Keeler Boone, Agent Solon, and Agent Greer, without reasonable suspicion or probable cause. Ma'am, to stop talking and comply? The Fourth Amendment to the United States Constitution protects citizens from unreasonable searches and seizures. The Supreme Court has held, in Terry v. Ohio, that law enforcement may briefly detain a person for investigative purposes only if they have reasonable suspicion based on specific and articulable facts that criminal activity is afoot. These agents have provided no such facts. The crowd was completely silent now, every face turned toward her. Arrington could see the recognition dawning. They were watching a constitutional law lesson being delivered in real time by a federal judge who was simultaneously its subject. The agents claim they are conducting an operation but won't describe it. They claim they have intelligence but won't specify it. They claim they observed parameters but won't articulate them. This is not law enforcement. This is a pretext for racial profiling. That's enough. Boone moved toward her, his hand closing on her upper arm. The grip was firm, but not yet painful. The kind of control hold taught in law enforcement training. Arrington didn't resist the grip, but she didn't stop talking either. I am now being physically restrained by Agent Boone. I have not committed any crime. I have not threatened anyone. I have not attempted to flee. I have simply asserted my constitutional rights and questioned the legal basis for this stop. You're being detained for refusing to provide identification. I told you my identification is in my briefcase, which you forbade me from opening. You created an impossible situation, demanding documents while prohibiting me from retrieving them, and you're now using that manufactured non-compliance to justify detention. This is a textbook violation of the Fourth Amendment. More security guards had appeared inside the glass doors. Arrington could see them talking urgently into radios. Someone had finally realized that something serious was happening, that a federal judge was being detained at the entrance to her own courthouse. Help would come, but it might come too late. Furthermore, Arrington continued, her voice steady despite Boone's grip tightening on her arm, the agents are stopping me at a courthouse, which raises First Amendment concerns. The Supreme Court has recognized a constitutional right to access courts. By detaining me here, said the agents are not only violating my Fourth Amendment rights, but also interfering with my ability to perform my judicial duties. She's resisting! Greer moved to her other side, his hand going to his cuffs. I am not resisting. I am speaking. The First Amendment protects my right to speak even while being unlawfully detained. Arrington kept her gaze on the cameras, on the phones recording, on the attorneys who would remember this moment. I am explaining the legal violations occurring right now so that there is a clear record for the federal civil rights lawsuit I will be filing the moment this detention ends. That got Boone's attention. His grip loosened slightly, and she saw uncertainty flicker across his face for the first time. She pressed the advantage. 42 U.S.C., which Section 1983 provides a cause of action for deprivation of constitutional rights under color of federal law. Bivens versus 6 unknown named agents extends that protection against federal officers. What you're doing right now, detaining a federal judge without reasonable suspicion based on racial profiling, is precisely the kind of conduct that creates personal liability. You won't just be sued. You'll be named defendants. Your careers, your finances, your futures, all of it becomes evidence in a federal trial. Stop talking! Boone yanked her arm, spinning her around. Hands behind your back. You're under arrest for interference with federal law enforcement. The crowd gasped. Several people shouted objections. A woman's voice cut through clearly. She's a judge! Oh, she's telling you she's a judge. Arrington felt the cold metal of handcuffs closing around her right wrist. The click was loud in the November morning, final as a judge's gavel. She didn't fight, didn't pull away. Resistance would give them the excuse they were looking for. Instead, she kept her voice level and clear. I am being handcuffed and arrested. The charges, according to Agent Boone, are interference with federal law enforcement. I have not interfered. I have questioned the legal basis for a stop, which is every citizen's right. This arrest is retaliatory, unconstitutional, and will be the centerpiece of my civil rights lawsuit. The second cuff closed around her left wrist, the metal tight enough to be uncomfortable but not yet painful. Professional, practiced. They'd done this before, probably hundreds of times. Why they just hadn't done it to someone who could articulate exactly why every part of it was wrong. Let the record show, Arrington said, her voice carrying across the plaza, that I am Judge Blythe Arrington, and I am being arrested at 8:51 a.m. on the steps of my own courthouse for the crime of asserting my constitutional rights while black. The transport vehicle was a white Chevrolet Suburban with ICE enforcement stenciled on the doors in aggressive block letters. It had been parked at the curb the entire time, Arrington realized. They'd planned for detention from the start. This wasn't a routine check that escalated. This was deliberate. Boone's grip on her arm shifted from control hold to something harsher as he guided her down the courthouse steps. She didn't resist, but she didn't help either. It forcing him to navigate her descent in handcuffs while maintaining his authority. The crowd parted reluctantly, people pulling out phones, some calling out objections that the agents ignored. "You're making a mistake." That was James Hartley, the immigration attorney. "That's Judge Arrington. Call the courthouse. Verify before you—" "Stand back, sir. Interfere with this arrest, and you'll be detained too." Greer opened the Suburban's rear door. The back seat had been modified. No handles on the inside doors, a plexiglass partition separating front from back, vinyl seats designed for easy cleaning after whatever happened back there. Arrington had seen transport vehicles before in evidence photos, but experiencing one from the inside was different. This was the machinery of enforcement she'd observed from her bench, now closing around her. "Chej, watch your head." Boone's hand pressed down on her skull, pushing her into the back seat. Not gentle, not violent, just the practiced motion of someone who'd loaded hundreds of people into vehicles just like this. She was a body to be processed, a problem to be contained. The door slammed shut. Through the tinted windows, Arrington could see the crowd pressing closer, could see Sarah Bennington from the U.S. Attorney's Office on her phone, hopefully calling someone in the building who could stop this, could see the security guards finally emerging from the courthouse, too late and too uncertain to intervene with federal agents. And she saw something else. A young black man in a UPS uniform, his delivery truck parked at the curb, holding his phone up high to capture the scene. He was filming deliberately, professionally, adjusting his angle to catch the ICE agents' faces, the courthouse in the background, the handcuffed woman visible through the Suburban's window. Their eyes met through the glass. He nodded once, a gesture of acknowledgement, of solidarity, of confirmation that he was documenting this, that someone was bearing witness. Jettison Banks? She'd learn his name later. 26 years old, former journalism student at Howard, who'd dropped out to support his mother through cancer treatment, now delivering packages and shooting documentary footage on his phone whenever he saw injustice unfold. He'd been delivering to the courthouse that morning, had lingered when he saw ICE agents positioning themselves near the entrance, his instincts telling him something was about to happen. His footage would be time-stamped, geotagged, and uploaded to 3 different cloud services before the Suburban left the curb. It would go viral by noon, trending by evening, and be entered as Exhibit A in a federal lawsuit that would make history. But Arrington didn't know that yet. In the moment, she only knew that someone was watching, someone was recording, and the case she'd been mentally building since Boone first stepped in her path now had documentary evidence. Boone climbed into the driver's seat. Solon took the passenger side. Greer stood outside, handling the crowd, telling people to disperse. Through the partition, Arrington could hear their radio traffic, dispatch notifications, status updates, the bureaucratic language of enforcement operations. Subject secured, en route to processing. Subject? Not judge? Not citizen? Not even a name. Oh, just a subject to be secured and processed. Agent Boone. Arrington's voice was calm. You're compounding your initial Fourth Amendment violation with false arrest. I'm a federal judge. My identity can be verified with a single phone call. You're transporting me to a processing facility for verification you could conduct in 2 minutes. Why? You'll be processed according to standard procedures, ma'am. This isn't standard procedure. Standard procedure would be verifying my identity before arresting a federal officer. Standard procedure would be checking with courthouse security, who see me every day. You're not following procedure. You're following through on a bad decision, because backing down now would mean admitting you profiled the wrong person. Silence from the front seat. The engine started. The Suburban pulled away from the curb, leaving the courthouse behind, leaving the crowd of witnesses, leaving the building where Arrington had dispensed justice for 7 years. She watched it recede through the rear window. The marble pillars, the brass doors, the words carved in stone, equal justice under law. The irony wasn't lost on her. They drove in silence through downtown. Arrington used the time to observe, to note, to remember. Every turn, every violation, every detail that would matter in the lawsuit she was already drafting in her head. The arrest without probable cause, the refusal to verify her identity, the retaliatory charges, the deliberate humiliation of a federal judge transported like a common criminal. She thought about the thousands of people who'd been through this same experience, stopped without cause. I arrested on pretexts, detained for verification that should take minutes, but stretched to hours or days. The difference was that she knew the law, had access to resources, would be believed when she told her story. Most people detained like this had none of those advantages. They just disappeared into the system, processed and deported or released after days in holding. Their Fourth Amendment violations documented nowhere except in their memories and fears. That was going to change. Arrington was going to make sure it changed. Not just for herself, but for everyone who'd been stopped, detained, and processed by agents who saw demographics instead of humans, who followed profiles instead of facts. The Suburban turned into a parking garage beneath a federal building. The door came down behind them, sealing off the daylight. Yet Arrington took a deep breath and prepared for the next stage of her unlawful detention. The next 3 hours would test everything she believed about justice. They would also provide her with the evidence she needed to win the largest civil rights settlement in federal profiling history. The processing center was exactly what Arrington expected. Institutional gray walls, fluorescent lighting that turned everyone's skin sallow, the smell of industrial cleaner failing to mask decades of fear and desperation. She'd seen photographs in case files, read descriptions in testimony, but experiencing it transformed academic understanding into visceral knowledge. They removed her handcuffs in a secure intake room, photographed her from multiple angles like she was evidence instead of a person. I fingerprinted her with the same professional detachment. No one made eye contact. No one asked questions. They were processing a unit through their system, following procedures designed to dehumanize. Personal effects. A woman in uniform, Agent Vasquez, her nameplate read, gestured to a plastic bin. Everything from your pockets, jewelry, belt, watch. Arrington removed her Cartier watch, the one her mother had given her when she made federal judge. Her wedding ring, her pearl earrings, the professional armor that announced her status was stripped away piece by piece, leaving her just another body in the machine. The briefcase? Logged as evidence. You'll get a receipt. Agent Vasquez, my judicial credentials are in that briefcase. My ID badge for the courthouse. My federal caseload for today. Oh, you're preventing me from performing my duties as a federal judge. Vasquez's expression didn't flicker. You'll be given an opportunity to make a phone call after processing is complete. I want to make it now. After processing. They led her down a corridor lined with doors, each marked with a number. The holding cells. Through the small windows, Arrington could see other detainees, mostly women, mostly brown and black, sitting on metal benches or pacing the small spaces. Some looked defiant. Most looked defeated. All of them looked alone. Cell 7. The door opened with an electronic buzz. The space was maybe 10 feet by 10 feet. Concrete walls painted the same institutional gray as everything else in this building. A metal bench bolted to the wall. A toilet in the corner with no seat or privacy. A single overhead light behind protective mesh. Nothing sharp, nothing that could be used as a weapon or tool, nothing that acknowledged the humanity of whoever was locked inside. How long will I be here? Until processing is complete. Vasquez stepped back. The door began to close. Agent Vasquez. Arrington kept her voice level. I want you to remember this moment. Remember that you're locking a federal judge in a holding cell without charges, without cause, and without due process. Remember it, because you're going to be asked about it under oath. The door closed, the electronic lock engaged with a click that sounded like finality. Arrington stood in the center of the cell for a long moment, letting the reality settle around her. She was in custody. Unlawfully detained? Yes. Unconstitutionally arrested? Absolutely. But detained nonetheless, experiencing the system from the inside in a way no amount of reading case files had prepared her for. She sat on the metal bench. It was cold through her suit pants, designed for maximum discomfort. The overhead light hummed with a frequency that would induce headaches after prolonged exposure. The air was stale, recycled through vents too small to provide real circulation. Every design choice in this room was deliberate, calculated to break spirits and manufacture compliance. This was what she'd been reading about in case after case on her docket. This was the machinery of enforcement, the processing center where constitutional rights went to die. Detainees brought here weren't people with stories and families and rights. They were subjects to be verified, categorized, and disposed of. Arrington pulled a small notebook and pen from her inner jacket pocket. They'd somehow missed it in the intake, and she wasn't going to mention it. She started writing. Times, names, every detail of her detention. The stop at 8:43, Boone's refusal to verify her identity. The arrest at 8:51, the transport to this facility. Cell 7. Agent Vasquez. The conditions of her confinement. This would be evidence. Every moment, every violation, every detail documented in her own hand by a federal judge who knew exactly what standards these agents were violating. She noted the time. 9:17 a.m. She was supposed to be hearing oral arguments right now. The attorneys in the Hollister case would be standing before an empty bench, confused about why Judge Arrington hadn't appeared. Her clerk would be frantic, calling her cell phone, getting no answer. At the system she'd served for 7 years would be grinding to a halt, because 3 ICE agents had decided a black woman approaching a courthouse must be someone who needed papers checked. The absurdity would be funny if it weren't so damning. Arrington closed her eyes, letting herself feel the full weight of the injustice. Not just what was happening to her. She'd be fine, eventually, once someone with authority realized the magnitude of this mistake. But what about everyone else who'd sat in cells just like this one? People who didn't have her education, her resources, her platform? People who'd been processed through this machinery and disappeared into the system without anyone noticing or caring? That was the real crime. Not that it had happened to her, but that it happened every day to people who couldn't fight back. So she opened her eyes and returned to her notes. When this was over, when she was back on her bench, she was going to make sure these agents and this system faced consequences that would change how ICE operated. Not just for herself, for everyone. The clock on the wall outside her cell read 9:23. She'd been detained for 40 minutes. It felt like hours. And for some people in cells just like this one, it wouldn't be hours. It would be days, weeks, sometimes months. Judge Blythe Arrington sat on a metal bench in a 10-by-10 holding cell and promised herself that this experience would not be wasted. It would become evidence. It would become change. It would become justice. She just had to survive it first. Miller Vance had been supervising ICE operations in the district for 8 years. Long enough to develop good instincts about when something was about to explode in his face. The call from the courthouse security chief at 9:47 a.m. triggered every one of those instincts. Miller, we have a problem. Judge Arrington didn't show for oral arguments this morning. Her clerk says she's not answering her phone. Security footage shows her arriving at 8:43, but she never made it through the metal detectors. We have footage of 3 ICE agents stopping her at the entrance. Vance felt his stomach drop. ICE agents? Under whose authority? That's what I'm asking you. Let me call you back. He pulled up the morning's operation log. There it was. Operation Safe Courts, authorized by Agent Keeler Boone. Intelligence-based enforcement action targeting undocumented individuals using the federal courthouse as a gathering point. Standard language, standard protocols. Except nothing about this was standard. Vance made 3 more calls. To Boone's cell phone, no answer. To the transport log, 1 subject detained at courthouse, currently in holding pending verification. To the intake desk, subject refusing to provide documentation, claiming to be a federal judge. Claiming to be a federal judge. Oh, God. Vance was moving before he fully processed the implications. Down 2 flights of stairs, through the security checkpoint, into the processing center where subjects were held pending verification or transfer. Agent Vasquez was at the intake desk, looking bored with her shift. The subject Boone brought in from the courthouse. Where is she? Cell 7. Won't give us anything except her name and title. Says she's a judge. Vasquez rolled her eyes. Just everyone's got a story down here. Show me her intake photo. Now! Vasquez pulled it up on her screen. The photograph showed a woman in her early 50s. Professional attire, natural hair styled in a neat twist. Expression of controlled fury that somehow made her look more authoritative, not less. And she was unmistakably Judge Blythe Arrington, whose photograph hung in the federal courthouse lobby alongside every other sitting judge. Jesus Christ! Vance's hands were shaking. That's actually Judge Arrington. That's a sitting federal judge. You have a federal judge in a holding cell. What? Vasquez's boredom evaporated into panic. Sir, she didn't have ID on her. She wouldn't. Because Boone wouldn't let her open her briefcase to get it. Where's the briefcase? Evidence locker. Vance was already moving. The evidence locker was accessed by keycard, reserved for items taken from subjects pending investigation. He found the briefcase easily. Expensive leather, professional, completely out of place among the usual items logged here. He opened it. Federal Judicial Credentials. ID badge for the Harold T. Edwards Federal Courthouse. Security clearance documents marked confidential. A tablet with her calendar showing today's oral arguments. Business cards with the Great Seal of the United States and the title Honorable Blythe Arrington, U.S. District Judge. They'd arrested a federal judge. They'd transported her in handcuffs. They'd photographed and fingerprinted her like a criminal. And they'd locked her in a holding cell for over an hour while she was supposed to be presiding over her courtroom. This was going to be a disaster. And not just for Boone, his career was over, but for ICE, for the department, for every enforcement operation they'd conducted in the past year. A federal judge had just been given a first-hand experience of exactly how the system treated detained individuals. She'd have standing, credibility, and insider knowledge of every violation. Vance grabbed the briefcase and ran to cell 7. Through the small window, he could see Judge Arrington sitting on the metal bench, writing in a small notebook. Calm, composed, documenting everything. He keyed the door open. Arrington looked up, no surprise on her face, just the cool assessment of someone who'd been expecting this. Judge Arrington, I'm Supervisor Miller Vance. I am so incredibly sorry. There's been a terrible mistake. Arrington stood slowly, tucking her notebook into her jacket pocket. So, Supervisor Vance, I'm glad someone finally decided to verify my identity, an action that could have been taken 90 minutes ago with a single phone call. I understand you're angry, and you have every right. I'm not angry, Supervisor. I'm documenting. Every moment of my unlawful detention is being recorded for the federal civil rights lawsuit I will be filing. She gestured to the cell around her. I've been in this holding cell for 62 minutes. I was arrested without probable cause, transported against my will, and processed like a criminal. All because 3 of your agents decided that a black woman approaching a courthouse must be someone whose papers needed checking. Vance felt sweat forming despite the cool air. Judge, I want to apologize on behalf of the entire agency. This should never have happened. I will immediately begin an investigation. You'll do more than investigate. You'll preserve all evidence. Body camera footage from all 3 agents, courthouse security tapes, transport vehicle logs, intake photographs, this notebook I've been writing in. All of it becomes evidence in my lawsuit. Of course, absolutely. And I want to assure you that we'll handle this with complete transparency. No. Arrington's voice cut through his platitudes like a blade. You don't get to handle this quietly. You don't get to offer me a private apology and hope I'll let it slide to avoid embarrassing your agency. What happened to me happens to people every single day. The difference is that I have the resources and platform to fight back. She picked up her suit jacket from the bench, shook it out with deliberate care. See, I want a formal written record of this detention. Every step, every violation, every agent involved. I want it documented in your official logs that you held a sitting federal judge in custody for over an hour. And I want my briefcase, my personal effects, and immediate transport back to the courthouse. Yes, ma'am. Of course. And if there's anything else we can do to make this right? You can't make this right, Supervisor Vance. You can only document what you did wrong so that when I sue your agency for civil rights violations, there's a clear record of how completely ICE failed to follow constitutional standards. She walked past him, out of the cell, her posture straight, despite the hour in detention. Vance followed, signaling to Vasquez to expedite the release paperwork, to return her personal effects. I'm to get Judge Arrington out of this facility before anything else went catastrophically wrong. But it was too late. The damage was done. A federal judge had just experienced the machinery of enforcement from the inside, and she was going to use that experience to tear the system apart. Vance made a mental note to update his resume. He was going to need it. The trial began 18 months after Judge Arrington's detention, though calling it a trial suggested some uncertainty about the outcome. By the time the jury was seated in the federal courtroom, not Arrington's courtroom, she'd recused herself for obvious reasons, but Judge Patricia Wu's down the hall, the evidence was so overwhelming that the defense's entire strategy was damage control. Arrington sat at the plaintiff's table with her legal team, a coalition of civil rights attorneys who'd taken the case pro bono because they understood its significance. This wasn't just about one judge being profiled. This was about establishing precedent, about putting ICE's enforcement tactics on trial, about proving that racial profiling was unconstitutional even when conducted by federal agents with badges and authority. The courtroom was packed, media in the back rows, civil rights organizations filling the gallery, law professors who'd flown in from across the country to watch history being made, and in the jury box, 12 citizens who would decide how much constitutional violations cost when they happened to someone who couldn't be silenced or intimidated. The plaintiff's lead attorney, Marcus Webb, stood for opening statements. He was 62, a legend in civil rights litigation, and he'd been preparing for this case since the day Arrington called him from the courthouse after her release. Ladies and gentlemen of the jury, this case is about a simple question. Does the Constitution apply to everyone or just to some people? Judge Blythe Arrington went to work on November 18th. She walked up the steps of the federal courthouse where she'd presided for 7 years, and 3 ICE agents stopped her, demanded her papers, and arrested her when she asserted her constitutional rights. He let that sink in. A federal judge arrested for asserting constitutional rights. The irony was heavy enough to feel. The defense will tell you this was a mistake, an unfortunate misunderstanding. They'll say the agents were following protocols, conducting a legitimate operation, that no one intended to violate Judge Arrington's rights. Webb's voice hardened. But the evidence will show you something different. The evidence will show you that what happened to Judge Arrington wasn't a mistake. It was a pattern. It was a practice. It was racial profiling with a badge. He clicked a remote, and the courtroom monitors lit up with courthouse security footage. The timestamp read 8:43:22 a.m. The angle showed the courthouse steps from above, capturing the morning crowd streaming toward the entrance. Watch carefully. You'll see attorneys entering the building, court reporters, defendants, witnesses. You'll see the ICE agents positioned near the entrance, and you'll see something else. They're not stopping everyone. They're not conducting random checks. They're watching the crowd. And they're waiting. The footage continued. Several people passed the agents without a glance. All white, all professional. Some carrying briefcases identical to Arrington's. Then, Judge Arrington appeared in frame, walking up the steps with her briefcase and morning coffee. The moment she came into view, all 3 agents shifted their posture. Boone's head turned. He said something to his partners. They moved into position. "Watch Agent Boone." Webb pointed to the screen. "He's not stopping to ask questions. He's not checking credentials. He's made a decision before Judge Arrington is within speaking distance. He's decided she doesn't belong there. And that decision is based on one factor: the color of her skin." The footage showed the stop, the confrontation, the crowd gathering. No audio, but the body language told the story. Arrington standing her ground. Boone becoming more aggressive. The briefcase that was never opened. The handcuffs that came out when she refused to submit to an unlawful demand. The jury watched in silence. Several faces showed discomfort, disbelief, dawning outrage. The defense will show you body camera footage from the agent's perspective. They'll tell you Agent Boone was professional, that he followed protocols, that he had no way of knowing Judge Arrington's identity. Webb paused. But ask yourself, why didn't he know? She told him. She identified herself clearly. She explained that her credentials were in her briefcase, and he refused to verify her claim because he'd already decided she was lying. Why? He let the question hang. Because in Agent Boone's experience, black women approaching courthouses don't belong there. They're undocumented immigrants to be stopped, verified, and processed. They're not federal judges. They're not authority figures. They're subjects to be controlled. The body camera footage came next. Boone's perspective, audio included. The jury heard Arrington identify herself, heard Boone's dismissive, "Sure you are," heard her explain constitutional law while he reached for his handcuffs. Some jurors were taking notes. Others just stared at the screen in disbelief. Then came the phone footage, filmed by Jedison Banks from his delivery truck. This version was raw, unedited, capturing the full scene with audio. The crowd's protests. Arrington's calm voice explaining the Fourth Amendment violations. The click of handcuffs. The door of the transport vehicle closing. 2 jurors were crying. The defense attorney, but Gerald Marks from the Department of Justice's Civil Division, did his best during cross-examination. He questioned the agents about their training, their protocols, their intentions. He emphasized that they'd released Judge Arrington as soon as the error was discovered. He suggested that the brief detention, only 93 minutes, didn't rise to the level of constitutional violation. But then he made a critical mistake. He called Agent Boone to the stand. Marcus Webb approached the witness box like a predator who'd spotted wounded prey. Agent Boone, you testified that you stopped Judge Arrington because she matched parameters for your operation. What were those parameters? We were looking for individuals who appeared out of place at the courthouse. Appeared out of place? Can you be more specific? Individuals who didn't match the typical demographic for courthouse personnel. What demographic is that, Agent Boone? Silence. Boone realized too late that he'd walked into the trap. Let me ask it another way. When you saw Judge Arrington approaching the courthouse in professional attire, carrying a briefcase, what specific factors made you decide she was out of place? We had intelligence suggesting. What intelligence? You've claimed intelligence throughout this trial, but you haven't specified what it was. Was it her clothing, her briefcase, her professional demeanor, or was it something else? Something about her appearance that made you assume she didn't belong at a federal courthouse? I was following my training. Your training to profile people based on race? No, I never. Then explain to the jury, Agent Boone, why you stopped a black woman in a professional suit carrying a briefcase, but you didn't stop the 3 white attorneys who entered before her dressed identically. No answer. Explain why you refused to verify her identity when she identified herself as a federal judge. She didn't have visible credentials. Because you wouldn't let her open her briefcase to retrieve them. You demanded documentation, then prohibited her from accessing it, then arrested her for non-compliance you engineered. Isn't that true? I was following protocols. Show me the protocol that says arrest first, verify later. Show me the training manual that says ignore a federal judge identifying herself because you've decided she's lying. Show me anything that justifies what you did. Boone couldn't. There was nothing to show because no legitimate protocol supported his actions. He'd profiled Judge Arrington, and the entire trial was exposing exactly how that profiling worked. The jury deliberated for 4 hours. When they returned, the verdict was unanimous. Constitutional violation, deprivation of civil rights under color of federal law, intentional infliction of emotional distress. Damages, $18.4 million. The courtroom erupted. Judge Wu had to gavel for order. Arrington sat still, composed, vindicated. $18.4 million. The largest civil rights settlement in federal profiling history. And every penny would go toward the nonprofit she was establishing. The Constitutional Defense Fund, dedicated to providing legal representation for individuals detained by ICE without reasonable suspicion. The case didn't just win money. It won precedent. It won policy changes. It won a promise that the next person stopped on courthouse steps would have better protection than Judge Arrington had that November morning. As she left the courthouse, through the front entrance this time, without incident, Arrington thought about all the people who'd experienced similar violations but couldn't fight back. This verdict was for them. This precedent was for them. Justice, finally, for everyone. The Department of Homeland Security moved quickly once the verdict became public. Within 72 hours, Agent Keeler Boone was reassigned to administrative duties pending further review. Agent Solon was transferred to a desk position in a regional office in Nebraska. Agent Greer resigned before he could be formally disciplined, but the real consequences went deeper than personnel changes. 6 weeks after the trial, Homeland Security Secretary Amanda Torres stood at a press conference announcing sweeping reforms to ICE enforcement protocols. New training requirements on constitutional limits. Mandatory supervisor approval for courthouse enforcement actions. Body camera footage to be preserved and reviewed for all detentions. Civil rights audits for every field office. The Arrington case exposed serious gaps in our training and oversight, Torres said, her discomfort visible. We have a responsibility to protect our borders and enforce immigration law, but we also have a responsibility to respect constitutional rights. Those obligations are not in conflict. They must coexist. Judge Arrington watched the press conference from her chambers. The reforms were good, necessary, overdue, but she knew they were also insufficient. The real change wouldn't come from policy memos. It would come from consistent enforcement, from accountability when agents violated those policies, from a fundamental shift in how ICE viewed the people they encountered. That's why she was devoting the settlement money, all $18.4 million, to the Constitutional Defense Fund. The nonprofit had been established 3 months after the verdict, staffed by civil rights attorneys who understood that profiling wasn't just an ICE problem, it was a systemic issue that required systematic opposition. The fund provided free legal representation to individuals detained without reasonable suspicion. It trained community members on their rights during ICE encounters. It tracked enforcement patterns to identify and challenge discriminatory practices. And it brought lawsuits, lots of lawsuits, against agents and agencies that violated constitutional protections. In the first year alone, the fund represented 147 clients, won 89 cases, and secured $4.2 million in additional settlements that were immediately reinvested in expanding operations. The organization grew from 3 attorneys to 15, from 1 office to 6, from regional presence to national impact. And Judge Arrington remained involved, serving on the board, consulting on legal strategy, and occasionally visiting detention facilities to observe conditions firsthand. She'd experienced the machinery of enforcement from the inside. She was going to use that knowledge to dismantle it piece by piece. Agent Boone, meanwhile, resigned from ICE 6 months after his reassignment. His name had become synonymous with profiling. In his case, a cautionary tale in civil rights litigation classes. He tried private security work, but the background checks always surfaced the Arrington case. He tried consulting, but no agency wanted to be associated with the agent who'd arrested a federal judge. The last anyone heard, he was working retail security in a suburban mall, stopping shoplifters instead of immigrants. The irony wasn't lost on anyone who remembered the courthouse steps that November morning. Supervisor Miller Vance survived the scandal, barely. He testified extensively during the internal investigation, cooperated fully with the reforms, and spent the next 2 years rebuilding operational protocols. He never forgot the day he opened Cell 7 and saw a federal judge taking notes on her unlawful detention. That memory informed every decision he made afterward. When Judge Arrington returned to her bench, her reputation enhanced rather than damaged by the ordeal. Attorneys who appeared before her knew they were facing someone who'd experienced the system from both sides, who understood not just the theory of constitutional law, but its application in the real world where rights were asserted or violated in split-second decisions. Her rulings became more pointed, her questions more probing, her tolerance for governmental overreach reduced to zero. When ICE attorneys appeared in her courtroom arguing for detention without hearing, for expedited removal without counsel, for enforcement actions at sensitive locations, they faced a judge who'd lived through exactly what they were defending. "Counsel," she'd say, her voice carrying the weight of personal experience. "I've sat in a federal holding cell, and I've experienced what your client agency does to people. When you tell me that a 3-day detention without access to counsel is reasonable, I want you to imagine spending 72 hours in a 10-by-10 room wondering if anyone knows where you are. Then, tell me again how reasonable that sounds." Her opinions became required reading in civil rights courses. Law students studied her dissents, her concurrences, her careful documentation of constitutional violations in immigration enforcement. She became known as the judge who changed ICE, though she'd bristle at the title. "I didn't change ICE," she'd correct interviewers. "I exposed ICE. The change, if it's real change, and not just public relations, comes from consistent oversight, from consequences when agents violate rights, and from a fundamental rethinking of who deserves constitutional protection. That work isn't done. It's barely started." 5 years after the Courthouse Steps incident, Judge Arrington delivered the keynote address at the National Civil Rights Conference. She spoke about her detention, about the settlement, about the fund and its work. But mostly, she spoke about the people who experienced what she experienced every single day. People without her resources, her platform, her ability to fight back. "The Constitution protects everyone," she concluded. "Not just federal judges, not just citizens, everyone. The Fourth Amendment doesn't have an exception for immigrants or an asterisk for people who look different or speak with accents. See, it says, unreasonable searches and seizures. Not unreasonable unless the person is brown. Not unreasonable except at courthouses. Unreasonable. Period." The audience stood, applauding. But Arrington knew the real measure of success wouldn't be speeches or settlements. It would be the day when ICE agents saw a black woman approaching a courthouse, and their first thought wasn't, "Check her papers," but "She belongs here." That day hadn't arrived yet. But because of what happened on the courthouse steps that November morning, because of the $18.4 million verdict that followed, because of the Constitutional Defense Fund, and the thousands of cases it supported, that day was closer than it had been before. Progress, Judge Arrington had learned, wasn't about one dramatic victory. It was about persistent pressure, consistent advocacy, and the refusal to accept that constitutional violations were just the cost of enforcement. She'd paid that cost once. She was going to make sure no one else had to.